So this is the Local Government Act 1888, right? And it is section 2(5)(b), right? Section 2(5)(b). And Richard Verb's channel and his colleagues who he's working with from other channels who are bringing all these claimed accusations against the local council authorities need to read this. I don't think this has been repealed, this part, but this is quite important. I think this could compromise their claims. I've put a complaint in on their behalf to the Judicial Conduct Investigations Office about this council tax issue. They're saying that there's so many fines they don't believe they've been lawfully authorised by any judges, and if so, what judge? And that the whole procedure has been set up by the clerks' associations, right? And so I put a complaint into the Judicial Office of Investigations because if those fines haven't been authorised by any identifiable judges, then we need to establish, which judges didn't do something. Not only what judges did do something, what judges didn't do something, but that a judge was claimed to have done. And then if the council has done it fraudulently, then the council is at fault. But it needs a judicial investigation because we need to establish what judges did do and what judges didn't do. And if they're not named, we don't know. So we can't investigate it because we don't have any names. So it has to be the Judicial Office of Investigations. Now, I found this in this 1888 Act, Local Government Act, Section 2(5)(b). Now, this changes everything to do with this. And this is something that I haven't heard this mentioned in the programme on Richard Verb's channel, which I submitted as evidence when you've got this guy looking into it all and investigating. And what I find is I'm researching something, like I've been researching this petition of right and the, all the origin of the jury to find out exactly what powers the jury have got and where the powers come from. And it does go to the right to petition and this groups of people going around looking for criminals, but they didn't make the decisions, but they got evidence on criminals and brought the informations, and those powers then extended. And then there's certain things, I found other acts, particularly through the 1500s, where only the king can appoint, the judges and justices under the seal, and then also any legal process or legal action or writ has to be made in the name of the king. And this is where the right to petition, which is a lot later in 1688 to all these tumultuous petitioning acts, 1661, and these acts in the 1500s. But the thing is, what makes the petition lawful is the fact that you're petitioning the king. And also they were putting people through ordeals up through till the 1100s and to the mid 1200s, but then they replaced it by a jury, right? People were put through trial by ordeal, like waterboarding and so forth, all those thrown in water, various things, right? But then they started to replace with juries. But the thing is, they could have this process whereby you could face the ordeal, or you could write to the king for a special investigation or a special procedure into. You could basically, with a jury or the ordeal, you could. There was a process to go directly to the king if you've been. And instead of facing the ordeal for the crime, you could ask for a special investigation, and that's directly to the king. And this is the whole thing about petitioning the king directly versus the assizes or the king's bench and the judges on the circuits and the justices of the peace and so forth, but even the jury, right? And they had the Appeal Jurisdiction Act, which they abolished, but you never needed it anyway, which was pointless when you've got the right to petition the king over any subject or matter. There's no point having the Appeal Jurisdiction Act procedures. So the thing is, it's important for me to establish this jury powers and jurisdiction of when you've got a jury by lawful process. It's not just a bunch of people going around. They're actually doing something. They're engaging. They're enforcing the law. So they're in pursuit of the rule of law through a legitimate legal process, which they're engaging in. And the thing with the right to petition the king is when you're accused of something yourself, you've got this right to petition the king. But also, it originates from the fact that the thing is, a lot of these petitions, if you haven't been accused of anything and you're not facing any charges anyway, when you are going around and getting the signatures of the public, the thing is, it's always by lawful process, by due lawful process. All the thing is, the petition is illegal action. It is a lawful due process. So all of these all of the judicial functions in law, the petition, you're using the law and you're entering a legal process. And it's the same with objections against the council if they're planning. And when you go around and collecting the signatures of the public, you are the one bringing the case. But the thing is, with the petition, you're actually getting you're getting the public. You are going and getting the verdict of the people yourself. And the thing is, because you are petitioning the king by legal due process, by lawful process and right, you've entered lawful process. And the thing is, when the jury then are signing the thing is, you set out in your petition what you're doing. And because you're informing the king, you're telling him what you're doing, and you're sitting out your terms, and you're bringing your actions, and you're saying, well, we need to do this, we need to put flyers out, we need to promote it, we need to do this. Even some of the other actions you're doing, if you might break something, also in these laws as well, which I'm going to attach, there is this bringing lawful action against the people versus the king, or causing to break the peace of the people versus break the peace of the king. You've got the right. The thing is, you could bring legal actions directly on people or grievances on people, right? And there was other jurisdictions other than the king until they brought all other jurisdictions under the king. The thing is, you've got the right to break the king's peace or to bring to bring grievances against the king. But then there was this thing where you couldn't bring grievances against the other people, another person, because you've got the right to petition the king or the government. So why would you go break someone else's, go put a sign on someone else's door or window or bring them hassle? But then when they brought it under the jury, and when they brought the fact that you're getting signatures from the public and they're supporting what you're doing and so forth, they're effectively making judgment that they're supporting. You've got the support of the people and the jury behind you when you through lawful due process. You're not guilty of an offence. You're the one bringing an action for another matter. And that's all documented in there, and it's all clear from these other acts that I've found now. Now, when it comes to the council, This will apply with petitioning the council when you're appealing, like planning permission, or when you're petitioning about saving a tree or stopping a highway. You're petitioning the council. This is the thing now, and this is like a unite. In fact, I've just made another video about the petition of right and so forth, and the fact that they repealed some clauses which really they say they're unnecessary, but they are necessary, and you can't repeal those clauses because they're the basic function of government. They are the skeleton function of the processes that we've got. And another thing is that that petition of right clause, I knew there was something to do with Magna Carta in that petition of right. When I read it, I'm like, this is like Magna Carta. Well, the thing is, some of the exact bits of it are copied exactly over from Magna Carta. So I knew what I was looking at. So that the origins of the jury and the judicial function and powers of the jury are straight out of Magna Carta and put into the petition of right. And it's very, very clear and obvious now what that role and function of the jury is. That if you have entered a lawful process by the proper process, the jury can decide on point of law or on their opinion that it's either or. Therefore, when they're signing petitions and supporting what you're doing, it's by their opinion that you can do that. And you've entered lawful. It is a judicial proper by lawful process, just the same as criminal or civil actions. And this applies for things with the council, like objections against building and so forth, when you're collecting petitions. Now, the thing is, when you've got... you don't always have to bring a petition into an objection with the council, but usually they ask people if they want to object. You've got the right to voice your opinion and object. But if you start doing a petition, you're petitioning the king, really... the local authority of the justice or of the local council, when you're petitioning His Majesty's government, you've got this. The thing is, in a criminal or civil case, when you have a jury, the jury decide, not the judge, and the judge makes the order. So when you're objecting to something against the council, really, when you bring it to petition, the thing is, if you are arguing a point of law in a court case, the jury can disregard that point of law and say not guilty. Now, in the council, when you're objecting to a highway or to a planning permission, you've got off point of law, or you can object about changing the aesthetic appearance of the village, or if it affects the environment. You have certain arguments, but that in your normal appeal process, they're asking the public to go state their opinion, but you can also just go purely on the opinion, I don't want it, right? And that's the thing that the council chamber don't like. But when you go further than that, and you start going to the public and getting them, and then you start doing a petition, which then you're bringing a legal case against the council. It isn't just objecting to a case that the applicants made, and because you're petitioning the king as well, there really is, like this whole getting a referendum over something if you reach a certain percentage, and the fact that it's a minister of government that approves the referendum, like Secretary of State for Transport or something like that. You are overriding the council authority with that, and it basically gets approved by a Minister of the Crown in Central Parliament of the department to which it pertains to, because you're overriding the council local chamber with a referendum which has to be approved by central government, because you're overriding what is the equivalent of the judge by the people, or taking it to the people's vote. The petition that the people are laying is overriding that council chamber and asking for it to go to officially to the whole electorate of that area. But you don't have to be from that electorate to petition for it. It says that in the Act of Law where you can override it. And also, now, why, verbs, at this point, anyone who's listening, and I'm submitting this to Judicial Conduct Office because this is to do with that council tax thing eventually, I'm going to try and explain why it affects its council tax claims now. Why does this 1888 bill affect that? Well, this 1888 bill really surprised me because I was pottering around looking for some more information on the petition of right and so forth. And when I got to the repealed part, it brought up loads of repealed other acts, and they're all interesting. And I thought, these are all relevant. And then some of them were even more relevant, and like the 1500s ones, because I've been looking more of the origins of the jury. And then that opened up the whole thing of, I've just been filled in now. I'm pretty much or the whole origin of the jury. And also there were different jurisdictions where under the king. There were some jurisdictions knocking around in this country, and then there were different processes under the Gaels and the assizes and so forth. But there were some other jurisdictions that weren't necessarily directly under the king. There were other people with justices and so forth, probably left over from parts of England that weren't conquered fully by the Norman conquest in 1066. So from 1066... 11 and 1200, you've got these more extended and remote places like Lancaster, Isle of Man, some places in Ireland, and other places that were you still had some justices and judges, because, like I say, you've got that whole judicial system of Ireland, which is still recorded. Which is some parts of Ireland further over were not even conquered till apparently Queen Elizabeth time. Elizabeth I. So they were still operating. They weren't conquered. They weren't conquered at all. I know Southern Ireland now is its own country, but, to do with different changes, they never were. And there were certain jurisdictions which weren't under the king and judges, and some of them had trial by ordeal and other methods of trial, but they still had elections and so forth. I'm like 15 minutes in now, and I only really needed to say this part about this, and I've made another video, and I got a bit annoyed about why they'd repealed those two provisions when it's in Magna Carta as well. It's not only in Magna Carta, but also in the Petition of Right. Well, that is the official, that is the definitive, that is what the jury is. It is what the jury is, and it is what the jury always has been. There was no... In 1968, when that was repealed, there was no changes to the function of a jury or what a jury is or is not whatsoever. And that is well established from Magna Carta. So the function of the jury can make a decision. It is the truth. They can make a decision on point of law or on opinion, as long as as long as proceedings are going through due legal process. And the thing about a petition to the government is, you're setting out, you're bringing the case and you're writing down your case and you're submitting it, you're sending it in, and you're getting people to support it. It's a due legal process. This is the thing. You are, it's all official. Now, with the council tax, right, it says here, Verbs probably won't like this. I really don't think he mentioned it in his video, but the chairman of the council is a judge. This says that the chairman of the council, right, possibly even the mayor as well, but definitely the chair, it says instead of mayor here, but this is from 1888. It says that they've got, unless it's been removed, but I don't think it has. And people might not like this, but the chair of the council is a justice of the peace in authority. So when it comes to fines issued by the council, the chairman of the council can issue them. He's got the judicial authority to do it. So that Verbs might not like that. But so that's important, because when this clerks association or society is saying that, the fines don't have to have the name of the person who authorised them or whatever, or what judge. Well, the thing is, the chairman of the council is a judge and he can do it. The thing is, though, that usually the council refer any criminal or civil matters to a magistrate's court to get, they've usually, like, when the council are issuing fines and so forth for building sites, like, for example, have been, making, exceeding the noise level limit or making noise out of hours, lawful hours or whatever, supposed to refer it to a magistrate's court. But the thing is, the chair of the council is a justice, according to this. So they don't need to send it to the court or refer it to the court. Now, this is the thing. If the chair of the council is just telling, the secretary to send a fine, and she's just sending them out under the authority of him, he's saying any fine that hasn't paid this or that, send it out. But this is the thing, has he got to read it himself and look at it, and is it meant to be in a proper session with him where he goes through them all, and as he looks at them all? If there's a massive pile of fines, now this is where it meets the argument from the Richard Verbs channel, right? Because they haven't figured this into it, because they didn't know this. I don't think, from what they've been saying, they don't think that it's been sent to a court, but they don't need to send it to a court. If this 1888 bill is still in effect, they don't need to, because the chair of the council is a judge. But why isn't it got his name on there? Why isn't he the administering justice named on there? The clerks say that he doesn't have the name on there, right? Now this is getting interesting, because if the chair of a council is a justice of the peace, That means he can be investigated by the Office of Judicial Investigations. And he can't lay the blame on the judges if there is anything wrong with the council tax fines. Right? So it's in a way they were wrong, but in a way it's actually brought the Judicial Office of Investigations more closer to it if there is something wrong. Right? So I don't actually think now that we're looking at judges, as you would say, judges who haven't actually signed these fines off. Now, they do refer matters to a court if you want to appeal it, a fine, and if you want to have a hearing. But because the chair of the council is not going to do that, is he? The chair of the council is not going to be a justice of the peace when there's loads of people going to court. It goes to the court, if you see what I mean, with a justice. But he's got the authority. It appears from the 1888 Act that he is a justice of the peace. It's almost like in those cowboy films in the 1800s, isn't it? When they go, "Hey, I'm going to deputize you," you know, like it's almost like that. And in fact, they created the function. I think they created it here because they set up the county councils. The thing is, that 1888 bill is setting up the county councils. And those county councils are the one which set all our area up here. Before in 1973 it became a metropolitan council. I pretty much preferred it. But they're even talking about corporations and franchises back then, which I really don't like. But anyway, so Verbs and Daniel. I don't know if Daniel might not have read this. He might not. No, he probably does. He probably knows that council chair operates with effective justice of the peace. If the when it goes through the council chamber and all that. Now the thing is, when councils make decisions like planning decisions, you get the councillors all vote on it, don't they? And they all put their hands up and they vote in favour or against. But the thing is, when we petition and we achieve a certain figure where we're entitled to a referendum, we're going above those councillors. Now, that's like the jury, the people making the decision, not the local elected councillors or ministers in Parliament. Now, it says that it has to be the Secretary of State who authorises, the Minister of Central Parliament who authorises a referendum, but you can have one. And all the people who sign the petition for it definitely don't have to be from that area, because the person who buys a property and puts planning permission in doesn't have to be from the area when he buys it. And it says in the Local Government Act that those provisions are when you use the right to petition enactment, you're not held to the commitments of that act anyway. Although I don't dispute that if you have a local referendum, that the referendum is basically it is the local people voting on the matter. That's once you obtain it. But to obtain it, the people can challenge the local people into a referendum by volume of signatures percentage. You can make your own. You can actually make up your own provisions. It says in the petition that you can make up in the Local Governments Act. It says that the provisions can be, if you are using the enactment of the right to petition, you can draft up your own terms of what the case that you're bringing will be, and effectively your own procedures. You could make up your own process and say, right, we want a voting process and we want it to be like this, and this is how it's going to be. And because you're applying for it for your lawful process, you can effectively have it if you get it approved. Like you can have a referendum held on your own terms and conditions if it gets approved. That's what it says. So now back to this council tax. I'm kind of putting two issues in this because I'm putting the council tax issue and this issue about the petition in the council as well for local referendums. But if the chair of the council is effectively a justice of the peace and acting with that authority, then it changes a lot in how you see the whole process. So with the council tax, what Verbs now is looking at is, has the chair of the council diligently been through the council tax payments, the failed payments, and has he authorised each one? And if there's a pile of them on the table that people haven't paid, can he say to the secretary, can he say, see that pile of fines over there? Can you see that pile of unpaid council tax fines? I want you to, every person who hasn't paid, I want you to send them a fine out. And if they don't pay it, then, send the bailiffs around or whatever, right? Or whatever he's going to do. But how does he make the order, though? That's the thing. Is he making the order, or is the secretary making the order? I think that's what the essence of what Vobes is getting at. If an order has to be made by a justice of the peace, if the chair of the council is a justice of the peace, and if he can make an order for someone to pay a fine, did he make the order or not? Now, if there's a massive pile of them on the table and they're all unpaid, and the secretary, she reads them all, he hasn't seen any of them, and she says, all of these fines are unpaid, Your Honour. And he says, are you sure that's the truth? And she says, yes. Then he can say, well, send them all, send the bailiffs around to them all. But if she, has she got to read all the names out to him, to make it an official procedure in even if it's not the court, even if he's got, powers in the council as chair, if he's got the powers of justice of the peace, if he can make the orders, have all the names got to be read out? Have all the names got to be read out to him, and has he got to hear them all in a hearing? And or can he give directions to the secretary or to the clerk? Now, but this is the thing. The thing is, in a normal court, in a criminal or civil case, can the judge say to the clerk then, or to a secretary, see that massive pile of criminal offences there, I hereby find them all guilty, send them all a fine. Can you do that without hearing the specifics of each case? Well, there's the criminal procedure rules. So this is the thing. What does that document that the clerks have conjured up? It doesn't have to have the name of the justice on there, but to be honest, whenever I've got prosecuted by a court, I've never had it never tells you the name of the justice. I've always got to chase it up. Like my judge Emma Fudge and Nick Watson, right? They're never named in any documents that give any order. If you want to know who the judge was, you have to ask them while you're there. Excuse me, Your Honour, what's your name? You never see it on any court orders or fines or summons. You never have the name. You've always got to ask. If you ask for it, they give you it, right? I was kind of like, really behind Vobes on this, and I'd added this complaint to my file, to my Judicial Investigation Office complaints, because I didn't open a new complaint for it. And then when I read this, I kind of felt like, I don't think that Vobes is right, because, it looks like the council, the chair of the council from 1888, he is a justice of the peace. Does that mean that he's doing these council tax fines properly? So this means that Vobes has got to re-scrutinise those clerks' rules and procedures, because I haven't seen them all. But at this stage, though, there is one thing in this when it comes to the Judicial Office of Investigations. You're not looking at some other judges giving authorisation on fines, because I don't think it goes to them. It's looking like the chair of the council is the justice of the peace with it, and he's not named on there. But is it going through diligent? Is it going through due legal process? And therefore, actually, if they want to criticise that set of procedure rules that the Clerks Association Society have drawn up, And if it is or isn't due legal process that the chair of the council is doing to authorise fines and bailiffs and so forth, then it definitely is the Judicial Office of Investigations, because the chair of the council, it would mean that he's under their jurisdiction. If he is acting as a justice of the peace and got those powers, that means that he is under the jurisdiction of the Judicial Conduct Investigations Office directly, not as a proxy through the courts, whether any other justice in the court did or didn't. You're only getting those courts involved if you challenge it, because it won't get heard in the council because he's doing council business. So it will go to the court with those justices who are there to deal with those matters when people want to challenge them. I think... and what I think Vobes was saying... What Vobes was saying in that programme is that effectively, if people want to turn up, they can challenge it. But if they all turned up, that there wouldn't be enough. It would be impossible for them to deal with them all independently. And then the fact of when they issue the fines, is it coming from the council or the courts? I think with the sheer volume of the amounts of what they're talking about, I think that there's something not right about it. I think there's something not right about it. I think that there's likely too many of them to properly process, and it's probably the same as why they've not with the fines for speeding fines, that they're not parking tickets. And when the police do conditional offers, the ticket office are processing so many in the jurisdiction of the police chief that there's so many of them, and only people who challenge it in court go to a justice. Now, police chiefs have got certain authorities and powers. I'm not too sure whether they can make judgments or not, but the thing is that this is another matter that I'm wanting to raise to Daniel Hedwin now, if he's even bothered to listen to it all. And this is something else that I found in I don't know if it was in Magna Carta. It's in the Scottish Bill of Rights in the 1689 one. It's the one that's got the same as the right to petition, but that you can't be imprisoned for petitioning activities in there. And it is that you can't, they can't force you to, they're not allowed to, they're not allowed to force you to admit crimes by reducing the penalty, the punishment. Like, they're not allowed to say, I've got this recorded. This is a matter that I wanted to raise with a proper lawyer and challenge them on. It says capital crimes, but it means serious offences. Well, it's serious if you're going to lose your driving licence. It doesn't explicitly say which crimes, but it says capital crime, which is, the thing is, you can break the law with fines and it's not too serious, but once you're looking at criminal charges, then it definitely is serious. And like losing a driving licence that's quite serious, maybe even dangerous driving for things like that. Offences which could face custodial sentences. It says that the principle of saying that they reduce your punishment if you admit a crime, that's what it is. The practice of reducing, saying that they will reduce, we're not going to execute you if you admit the crime, or giving promises of reduced punishments if you confess to crimes. That practice is illegal by that 1689 bill, the Scottish one. And therefore, I've noticed that this whole fast track speeding offences thing that they set up, which is a modern thing. They didn't have this in the 1970s. It's like this fast-track process, what the police chiefs are doing with their ticket officers. In the ticket office, I'm just trying to find that Professor Karen Bowie paper, or the Claim of Right. I keep forgetting. It's the Claim of Right. The Scottish version is the Claim of Right. The Claim of Right. So in the Claim of Right, it sets out a basis in law, and that basis is that it's illegal. It's an illegal practice, a perversion of the course of justice, is to promise reduced punishments if you confess to crimes. So and give information, if they say, basically, if you've been accused of stealing someone's horse, and if the sentence was, execution, if they said, if you confess to killing the horse, or if you give us information on it, we won't kill you, basically, right? Now, the thing is that with the speeding fines, what they're doing is that they're saying that, when you break the law, you've got to go to court, right? If you've broken a law, you've got to go to court to find out whether you're guilty or not. But what they do with the police is they've got this conditional offer. It's a condition, and they reduce. They give you a fine, and if you refuse to pay the fine, then the fine increases. It's more. At first, the fine is, if you accept £60 fine, and pay it within 30 days, you have to go to court. If you or the fine, it will go higher if you don't pay it within these times, right? Now what they're getting you to do is give them information, who was driving the car, or a confession. And what they're doing is they're saying that you won't have to go to court, and they're not going to charge you with an offence, and you won't have to defend it in law if you accept this offer. So it's like a reduced punishment. It is a condition, the conditional offer. Now, according to the Claim of Right, 1689, that principle is unlawful, and it's one of the actual main clauses in there, other than like that clause that you're not allowed to be imprisoned for petitioning the king, right? So I really think that, and the thing with all those conditional offers is people don't end up having to go to court. Now, if everyone didn't accept those conditional offers and everyone went to court, the courts won't be able to deal with it all. People end up going to court on the final one because they don't keep giving you conditional offers. They say once you've got 9 points or whatever in your license, or 12 points, then you go to court. Now, they're not saying at that point, if you pay a fine, then you won't have to go to court. They're actually making you go to court at that point when lots of people don't bother turning up. And they don't give evidence. A lot of them, just don't turn up because they're scared, and then they get disqualified, which is inevitable unless they get a lawyer at that stage. Now, why didn't they get a lawyer at the first earlier stage and prove themselves not guilty to get the first 3 points? So then they didn't have any points. And why didn't they do it at another stage and never have any points at all? Because they weren't guilty. Well, they're admitting guilt for a reduced offer. And my argument to Daniel Hedwin is that I believe that by the Claim of Right, the 1689 Claim of Right, that principle is illegal. What classes as a capital crime? Well, serious offences. It's always serious if you've got to go to court. Look at parking. What's a parking ticket? Well, it's illegal. It's illegal to park without a ticket, but it's not a capital crime. The thing is, with driving license, if you turn up at court, it is serious when you're facing losing your driving licence, because when you need it for your job, it's quite serious when you need it for your job because you can't work. When you're Magna Carta, you're not allowed to take your car away from you anyway. You're not allowed to take your car away from you, and there's meant to be defence in law that if you using keeping a schedule and you need it for your job, then it's meant to be defence. But then that provision never got upheld. So I really believe that the entire, and it's not that old. The thing is, this is only probably in my lifetime, when they conjured up this procedure, this practice of this fast track ticket officers processing tickets and getting people to admit fault and so forth. I think that it's illegal. I think that it's unlawful, and they're trying to get maximum number of fines and tickets out of people. I think it's illegal, and by the act, and also I do think there's something probably wrong with these council tax fines, but as Verbs says, I don't think that Verbs recognised in that programme that he covered this topic. I don't think that they had seen this act, and I don't think that they'd realised that the chair of the council has got authority of justice of peace, which it says here. So that would kind of like, if you go to court. You can go to court, to challenge the fine or whatever, or they can refer it to a court. But to the council chair can authorise the documents, and I guess you don't have to be named on there according to the Clerks Association. But if they are processing that number of them, and regardless of what the Clerks Association process is that process lawful? So what we're looking at now, we're looking at the chair of the council, I think, and we're looking at if he is batch authorising large numbers of payments, or even sending the bailiffs, are all of them being given due process of what is required? And does he even need to hear the names of the people? Does the clerk have to read them to him, or can she just say 500 people or 50 people, and he just says, stamp them all and send them the bailiffs around to them all? Has he got to have they all got to have a proper hearing by him, or have their names got to be heard, and have the particulars of each case got to be read to him and heard, or can the clerk just say, I've read them all? And if so, does that mean the clerk can hear cases himself without the judge? As the clerk being given judge powers? I've been reading the procedure rules and so forth, and there are a lot of things that the clerk can and can't do. So this updates my complaint about this council tax issue that's been raised by Richard Verbs. It now looks like that it could be the chair of the council, and he can be investigated by the Judicial Office of Investigations directly. And I've also got a complaint about the speeding fines and the whole process of the speeding fines by the claim of right, because I think that it's promising reduced punishments by getting you to admit, give information or even admit guilt, and that's illegal. It's an old practice and principle, but it's the basis is unlawful. Never mind illegal road signage. You haven't even got that. That's not even without the illegal road signage. So, and then the other thing is, I brought up the issue of juries. Can the juries decide? Well, if it's lawful process, yes, they can. If they're engaged in lawful process, they can, and they don't have to decide on point of law. And I think that in planning orders and planning objections and planning applications, remember that a lot of people who buy houses and apply for planning aren't from the area. So if someone's from Cornwall and building a house in Scotland, they don't even live in Scotland, they're bringing a case to the council that they want judged so they can build there. Why should the people who sign a petition to stop them be from Scotland? But they surely can compel the people of that area into a referendum. So, and then the final point is this: looking at the petition of right. That petition of right, the 1620s one, that is from Magna Carta. And I said this in another video, that there were lots of things that refer to Magna Carta in that bill. In fact, it actually turned out that the main paragraph that I was referring to is from Magna Carta. But I must have subconsciously knew that, because I was saying that this whole thing sounds like Magna Carta. Because it is the provision from Magna Carta, and that provision from Magna Carta was actually in an act of law, not just like when they've revoked that in 1968. They haven't changed the function of the jury, and if the function of the jury was that they can make decisions based on their opinion and not on point of law, as long as it's through lawful process, due process of law, then I don't see whether a court in 1965 and a court in 1969, that there's no fundamental change to how a jury operates and what they can and can't do between that time. They haven't changed it because the jury's role. They haven't changed the law on what a jury can and can't do. The reason for it being revoked, it says it was not required. It says, this is like, as if they were saying, this is just like, it's surplus. It's surplus legislation. It's kind of like, it has no point. It has no meaning. It's unrequired. Well, what it turns out is that piece of legislation is a foundation. That's part of Magna Carta. That's from Magna Carta, which is what, David Cameron MP says. Magna Carta, the founding law of the nation, the oldest, one of the main, one of the main pieces of law by which all the standards are based on, which is setting out, the framework and what it actually is we're dealing with. And then they're claiming in 1968. Why would you repeal that in 1968 and then say the reason for repealing it was that it's not required? Well, of course it's required. What it said is that no one can be prosecuted without lawful due process. It said no one can be prosecuted without lawful due process. You can't revoke that. The part of Magna Carta which has been copied and put into modern law, which is what you call your skeleton, your foundational basis structure, you can't revoke that in 1968 and say that it's not required anymore. Well, so to be prosecuted, let me get this straight. So the requirement for due process of law to be used is not important. It's not required. But that's why it's almost like being stood in court and saying, I'm on, you're on trial, but not by due process. Well, what process am I on trial by if you revoke due process, the requirement of a due process of law? It doesn't make. There's something really, really